of what a 20-day notice requires and what the contents are. We haven't used this enough. We didn't use it enough yesterday, so we can all be looking up at the same place. All right? 20-day notices, what are they? They're an innocuous single sheet of paper that is mailed out to parties on a project. If on page 4 you're seeing that it's just a simple page that notifies the owner of the project and the general contractor that you are supplying materials or labor to the project. It preserves your lien rights, your stop notice, and also your payment bond rights. What are the contents that are required in a preliminary notice? First of all, a general description of what you are supplying, okay? Whether it's labor, materials, it doesn't have to be exact, but they should have an idea of who you are and what you're supplying to the project. The name and address of the person furnishing it, that's you, of course. The name of the person who contracted for the purchase, that is your customer, right? A description of the job site sufficient for identification. For a preliminary notice, a legal description is not required. Merely an address or a location of the project sufficient that everyone knows what you're talking about. Sometimes you're just going to have cross streets because it's phased housing, all right? That is sufficient if people know what you're talking about. A statement in bold-faced type intended to explain the contents to the owner. We're going to show you what that looks like. Who has to receive it? First of all, the owner of the project has to receive a copy of the preliminary notice. Doesn't matter whether you're in direct contract with the owner or not. The original contractor to the project, the construction lender. This is very important. You need to find out when you're doing a preliminary notice if a lender has loaned to the project. It didn't used to matter that much because lien claims in Arizona are not required to identify the lender to the project. And frankly, people extrapolated backwards from that and said, you know, so it really doesn't matter on the prelim either. And a lot of times no one's sure if there's a lender. Judges are looking at this very differently these days. And as things get a little bit tighter economically, we find that the attorneys for the project owners, for the general contractors, are much more aggressive in looking at the preliminary notices and deciding whether or not it meets the statute. How must service be? The other people, the person with whom you contracted, you got to send the information to them. The general contractor, if different from the original, and the reputed versus actual parties. What are we talking about on reputed versus actual parties? Sometimes you don't know who the owner is. You did your very best and you just couldn't figure it out. We look at the assessor's website and we put in the address. It's a very simple process, and they will take you directly to the deed of trust. And from the deed of trust, you can generally determine whether there's a lender and what the proper names of the parties are. All right? But as long as you made a good faith effort and out in the public domain, the information you have on your preliminary notice matches what's there, then you conducted yourself in good faith. How must service be made? First-class mail with certificate of mailing. That's sufficient in Arizona. First-class mail with certificate of mailing. Now what that is a sheet of paper that has the addresses that you sent the preliminary notice to, and you put it in front of the postal worker and they stamp it, and that's sufficient. It does not have to be sent certified mail return receipt requested. It can be, and that's a higher level of proof that your preliminary notice went to the location you say it went to, but it's not required under the statute. Service is complete at the time of the deposit in the mail. All right? A 20-day notice is defined as a notice that was served within 20 days of your first supply of materials or labor. All right? And so service being complete upon placing it in the mail is very, very important because you can only reach back to secure the last 20 days of supply of materials and labor. Hi, folks. Derek, could you supply them? Welcome. You missed the quiz at the front end. It's very important. You'll want to hear about that later. A couple of practical tidbits on that. The post office picks up from certain mailboxes at different times of day. If you have a meter in your office and you meter something for the 20th day, you just barely hit it, and on suppliers this really matters because on labor contracts, it's prorated. You're supplying labor each day, and you're going to be able to reach back and capture most of that labor. But with supply contracts, it's the date the materials went to the site. All right? You can only reach back 20 days to grab those, and if you miss that by a day, you're out of luck. So you may think, okay, it's 11 o'clock at night, I metered it on our office postal meter, I'm going to drive over to the Safeway where there's a post office box, right outside it, drop it in there, I'm good. Wrong. Because that's probably picked up about 4 o'clock in the afternoon, and they're going to have a counter stamp on the envelope. Not to mention the fact you don't have a certificate of mailing when you do that. You got to plan ahead on these 20-day notices. I highly recommend that you use a lien service unless you're staffed up internally to deal with this yourself effectively. And you can do it. I mean, we do it on Word documents. You can have your own Word document that you fill in and handle this, but a lot of times it's good to have people whose entire job is to do that, like at a very competent lien service. Okay, 10-day request for information, corrections, and payment bonds. Why don't we just move over to the body of the preliminary notice, and I can explain what those things mean. All right, so this is what it looks like. Again, this is a document if you want to secure your lien rights or your payment bond rights in all but federal bond situations. You want to put a 20-day notice in the mail, and you're required to do so, identifying who, as you can see on the upper left side, the owner or reputed owner, the original contractor or reputed original contractor, and by the way, you also want to have the current contractor if different from the original, the lender, and the surety or bonding company. All right? Now, the surety or bonding company is not required. The surety or bonding companies, welcome. They're not required to get this, okay? Let me tell you why you should put the surety and bonding company on your preliminary notice every single time. In the second seminar this morning, we're going to be talking about payment bond rights and 90-day letters. 90-day letters are not elaborate documents. And a preliminary notice can satisfy the requirements of a 90-day letter, and sometimes you've got no choice but to rely on having sent a preliminary notice because you missed the 90-day deadline after your supply of materials or labor. So, if you've got the surety or bonding company on here, you've got a little bit of a safety net. Right side of the page. You're hereby notified that the undersigned claimant has furnished or will furnish labor, materials, machinery, fixtures, tools of the following general description. This one had concrete in it. An estimate of the total price of the labor, professional service, material, tools furnished or to be furnished is. Now, this is not necessarily the entire size of your contract to this project. If you're a subcontractor, you're going to have a price for the entire portion of your supply of labor and materials. If you're a material supplier, you're not going to. You're just kind of estimating how much that you think you're going to supply. So you supply, you think you're going to supply $50,000 to the project. You can put in $50,000 or up it, say another $10,000 or $20,000. The reason is this is not a recorded document. And there are no penalties for overstating the total value of materials that you think you're going to supply to the project. So you can estimate a little bit above that. The other thing is, in Arizona, we have a 120% rule. Now, that 120% rule says that you have the opportunity to record a lien claim for 120% of the stated value on your preliminary notice. So if you put $50,000 there, and then it turns out that you supplied $60,000 in materials to the project and you were not paid for that, you can record a lien claim for $60,000 because, a little simple math, $60,000 is 120% of $50,000. If you supplied $65,000 to the project, and your preliminary notice was for only $50,000, you would not be able to record a lien claim for that $65,000. You would have had to supply a second preliminary notice with a higher dollar value in order to capture that additional $5,000. Now, another practical tip here on preliminary notices. Listen, you may think at first that you're supplying only $20,000 to a project, particularly if you're not entirely sure what the project is comprised of. Sometimes there'll be 4 office buildings in a park, and you thought you're only supplying to building B, but it turns out that your customer has got a contract for all 4 buildings. Tremendous. But instead of $20,000, say, worth of paint, you're now going to supply $80,000 worth of paint. So January 1, you supplied the first $20,000. You sent out a preliminary notice on your very last date, January 21. It reached back 20 days and captured that supply of $20,000 worth of paint. But then come February 1, your customer says, I need another $40,000 worth of paint. So you've got till February 21 to amend or send a second preliminary notice out. This is how we do it. And we used to, at an old law firm, we used to do preliminary notices, and we actually had one of the larger lien services in the state. We just don't do it that broadly anymore. We're much more discreet in preliminary notices we do in-house. But this is how we did it. We sent out what we called an amended preliminary notice. Okay? Amended because if there was, for any reason, we wanted to reach back and get the benefit of the January 21 preliminary notice, we wanted to have that option by saying it was amended. Let's say, for some reason, we had typographical errors on the second preliminary notice. If we're saying it's amended and we got it right the first time, then you've got a little more maneuvering room. But on that amended preliminary notice, we do not put in $40,000. Welcome. Welcome. If we send out an amended preliminary notice, we put $60,000 in. $60,000. We capture the entire amount of supplies to date. Why do we do it that way? Because some judges will look at your second preliminary notice as replacing the first one. All right? And they'll say, hey, your February 1 preliminary notice is new, and it replaced your January 1 preliminary notice. So now the total amount you can lien for is 120% of $40,000 instead of $20,000. You say, no, 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 no. Those preliminary notices are independent, separate, and we get the total value, which is $60,000. And that's actually the correct legal answer. But a lot of judges these days are not coming from necessarily the civil side of life. They're coming from the criminal side of life. They were prosecutors or public defenders, and on the bench they've done a lot of criminal trials, and so they just don't know this stuff. And this is the kind of thing you don't learn in law school and you don't learn on the bar exam. You only learn it by practicing in that field of law. All right? So we call it amended to grab the benefits of the first prelim, and we put the entire dollar value of materials supplied to date, even though that amended preliminary notice cannot reach back and protect the first $20,000 of materials at the site. It can't. So the reality is that you are still dependent upon those 2 separate preliminary notices. All right? But it's still protective. Okay, the name of the person with whom you contracted, that's your customer, and the description of the job site is. Remember here, all you need is a physical address, no legal description, and it's sufficient to identify the project. So it can be cross streets. It could be addition at Phoenix Children's Hospital over by Thomas. Everybody will know what you're talking about, or I don't know where to, over by the highway. But you can do better than that. You want an address. Now, this is a statutory notice that's required to go to the property owner. You know, let's take a second and read this because, frankly, it's something you're never going to read otherwise. So let's do it right now. Notice to property owner. If bills are not paid in full for the labor, professional services, materials, machinery, fixtures, or tools furnished or to be furnished, a mechanic's lien leading to the loss through court foreclosure proceedings of all or part of your property being improved may be placed against the property. You may wish to protect yourself against this consequence by either 1, requiring your contractor, remember, this is the owner who's reading this now, okay? This is the person's eyes you're looking through. Requiring your contractor to furnish a conditional waiver and release pursuant to Arizona Revised Statutes, Section 33-1008, subpoint D, paragraphs 1 and 3, signed by the person of the firm giving you this notice before you make payment to your contractor. 2, requiring your contractor to furnish an unconditional waiver and release pursuant to Arizona Revised Statutes, same section, paragraphs sub 2 and 4, signed by the person or firm giving you this notice after you make payment to your contractor. And 3, using any other method or device that is appropriate or under the circumstances. So what they're saying is, if you're the owner, before you pay, you may want to get a conditional waiver and release, and after you pay, you for sure want to get an unconditional waiver and release. We'll talk about those in a moment. Then, below that, within 10 days of the receipt of this preliminary 20-day notice, the owner or other interested party is required to furnish all information necessary to correct any inaccuracies in the notice pursuant to Arizona Revised Statutes 33-982-01, subsection 1, or lose as a defense any inaccuracy of that information. This is a very friendly provision for suppliers, contractors, and builders have to be aware of this, that this is a defense to inaccuracies in the preliminary notice. What does this mean? If you got something wrong, other than the identification of the parties required to receive the notice, then unless someone receiving the notice corrects that, the inaccuracy in the preliminary notice doesn't invalidate the prelim. Okay, the most frequent type of example here is getting the project identification or the location wrong. Okay, you just weren't exactly certain where it is. The only person at your company who has eyes on the site is usually the sales rep. All right, and sometimes they don't have eyes on the site. They're relying on the customer to tell them where this project is. But if you identify it sufficiently that everyone knows what you're talking about, or if you just got it wrong, nevertheless, if no one corrects you within 10 days, then you're okay. Now, you can't get it wrong on the lien claim. You got to get it right then. The lien claim's got to be bulletproof. But the preliminary notice does not have to be bulletproof if everyone who was supposed to get it got it and they don't correct misinformation. Within 10 days of the receipt of this preliminary 20-day notice, if any payment bond was recorded in compliance with ARS 33-1003, the owner has to provide a copy of the payment bond, including the name and address of the surety company and bonding agent providing the payment bond to the person who has given the preliminary 20-day notice. In the event that the owner or other interested party fails to provide the bond information within that 10-day period, the claimant shall retain lien rights to the extent precluded or prejudiced from asserting a claim against the bond as a result of not timely receiving the bond information. What's going on there? Sometimes on large projects, there's a private payment bond that's taken out. Big grocery stores, big shopping malls, hospitals. There are so many suppliers of labor and materials that the owner of the project is saying, if you're going to be the general contractor on this, I want to see a payment bond for this entire project. I don't want to get hung up on all kinds of lien claims. And in that case, the general contractor, the owner, can't lay in wait for your bond rights to expire because you thought there was no bond and you recorded a lien claim, or you sent out a preliminary notice and were waiting because the lien claim deadlines here in Arizona are fairly generous on time frame. They have to tell you, as the preliminary notice states, within 10 days if there has been what's called a discharge bond or simply a private payment bond. And if they don't, then you can proceed on your lien rights. Okay? So there's some affirmative duties on behalf of the owner here. So it's signed by somebody, it's signed by whoever's preparing the preliminary notice, it's dated, and then at the bottom there's an acknowledgement of receipt which no one ever signs and sends back, and there's absolutely no requirement that they do. All right? But there it is. Acknowledgement of receipt of the preliminary 20-day notice. That's prelim. Yes, ma'am.
Is there any particular way that they're supposed to furnish you with the information to correct inaccuracies? I mean, what if they just call you up and say, oh, no, this is this? And
yeah. If they can verify, if they can verify that they corrected the information, that's sufficient. They can call you up and tell you that. Most of the time, what you'll see, if they're actually correcting it, is they'll change it right on the preliminary notice and they'll mail it back to you, sometimes by certified mail return receipt. Now, you've got to, as quickly as possible, turn right back around and get that preliminary notice out, corrected to all the parties. And there's no statutory deadline for doing that. Presumptively, it's within 20 days. I like to stay within those 10 days because that's you know, the context. That's the timeline context that's running there 10 days. So you want to get it out again by at least a certificate of mailing to prove that the amended preliminary notice went out to the parties. Yes, ma'am.
I'm in the middle of a bond claim. The original project, my customer supplied the wrong bond comfort surety information, and I found out after the fact, and I went forward with the bond. I'm going forward with the bond claim. Because I never got that correction back from anybody, I'm protected?
Well, is this a state or federal claim?
This is a state claim.
Okay, and it really doesn't matter. I'm just curious. It helps me think it through. You don't have to have the surety and the bond information on this preliminary notice.
Well, they give me one and it happened to be another, so the wrong surety got the free one.
Well, and what I'm saying is it doesn't matter. You didn't have to put any surety on the preliminary notice. Now, even on the 90-day letter, and this is really for the second session, but you're required on what's called a Little Miller Act in Arizona to send a 90-day letter out to the general contractor, and they have to receive it within 90 days of your last supply of labor or materials. That does not have to go to the surety. That only has to go to the general contractor. Now, the information in that 90-day letter should be accurate as to who the surety is. But if you wanted the best information you had, as long as you put the general contractor on notice of the fact that this is a payment bond claim, and we know the payment bond that we're talking about, then that should be sufficient. You have a lot of maneuvering room in your situation. The big thing is to hit the timelines. Okay? All right. So that's what a preliminary notice looks like. Questions on prelims?
You have to have a dollar amount in there, because Arizona requires a dollar amount.
Arizona does require a dollar amount. Now, other states, certain other states don't require a dollar amount. Here's what we do. We generally increase the dollar value of the preliminary notice by 25% or so. Now, it depends on whether we're dealing with someone, a subcontractor, or a material supplier sometimes will have a subcontractor element to what they're doing, or whether it's just a material supply contract. If we know the entire value of the contract on the project, typically we're going to put that entire value in on the preliminary notice if we're doing it for a sub. For a material supplier, they're not sure what the total value is they're going to supply to the contract, then we take it up by about 25%. Sometimes the general contractor will be upset by the size of the dollar value that's on there. So you want to take the political implications into effect. But one of the things to remind these people when you deal with them on the phone, they're irate that you sent a preliminary notice, it's not a recorded document. This didn't disparage the title to their property. Okay?
Jim? What
Yes,
about
sir.
a public project? Do you still have to put an amount, an estimate in the prelim for that?
Yes. And the thing that you need to be aware of in Arizona is for state public projects, you've still got to do a preliminary notice unless you're in direct contract with the owner entity. Okay? And in that instance, the only parties in direct contract with the owner entity are generally going to be general contractors. Now, there are times that even a paint subcontractor will be in contract with the owner entity, such as someone painting lockers on a high school. They may be contracted directly with the school district, in which case you don't have to send a preliminary notice in Arizona for that for that public project. But here in Arizona, both public projects, private projects, got to send a preliminary notice with a dollar value. Okay, now this is the big dog, which is a lien claim. This is the reason you're sending out a preliminary notice, because you can't record a lien claim in Arizona without having first given notice in the form provided by statute that you are supplying labor and materials to the project and giving that notice to the owner and to the other parties listed by statute, the general contractor, the lender, your own customer. What is a mechanic's lien? A mechanic's lien is a document that you record with the county recorder in the county in which the property is located. One of the last things I like to do before a document goes out of our office And again, I'm an attorney, but sometimes we're doing these more preliminary documents for the client because, say, there's a lot of money involved, or they just, they're short-fused on this, and their lien service can't turn it around in time. Or they want to be sure that some of the materials looked up online. Lien services are getting very, very good at doing this, but it's a little bit of a new environment where they're actually looking up lenders through the county recorder's office and that sort of thing. And the other thing is some counties don't have that information available online. You got to deal with the county recorder and finesse that information out of them, and sometimes, so that's why they look to a lawyer on occasion. So I do what's called an idiot test before a document goes out of the office, and that test goes like this. What kinds of things, if I make a mistake on it, make me look like a complete idiot? All right, it's as simple as that. Are the party names correct? Is our customer correct? But here's the biggest one, is the county correct? You know, Prescott is up in Yavapai County, and everybody uses forms. Everybody uses templates. And sometimes you're going to use a lien claim. You're going to start from your template, which is in Maricopa County, and you just forgot that this is up in Prescott, or it's up in Flagstaff, which is Coconino County, all right? And you've got to get that right. And the other thing is, if you've got Maricopa County there, even though everybody knows the project description is in Yavapai County or something like that, things just cascade. You might go, okay, so this is going out to the Maricopa County recorder. It just gets bad. And if you're at the far end of your timeline, you're about to run out of time, you know, you've got to have that stuff right. So that's not a small thing to make sure you've got the county right. Okay, a mechanic's lien is a secured remedy available only on private projects, never on public projects. Also, no party can claim a lien against dwellings of owner-occupants unless in direct contract with the owner. So what does this mean? If you've got a customer who's doing work on a $1 million mansion, all right, if it's owner-occupied, meaning the owner is going to reside within that residence for 30 consecutive days during the 12 months immediately following completion of the project, it's considered an owner-occupied project. In that case, you cannot lien it unless you are in direct contract with the owner. Now, some owners function as their own general contractor, in which case they might actually take out a credit application with you. But if you're a supplier to a subcontractor, even if that sub is in a situation of direct contract with the owner, you're not. So they may be able to lien the owner-occupied residence, but you can't. Now, one client had me draft up a letter that goes to the owner of the residence and says, look, you know, I need you to sign this, that you will guarantee the payment of materials on this project, or else we're not going to supply. That's a little dicey. That, you know, that can cost you a relationship, and probably in half of the instances, it will cost you the relationship on that project. All right, but it's an option. Okay, the owner may withhold funds from the general contractor equivalent to the lien claim value unless otherwise due to the general contractor in the absence of a lien. All right, what does that mean? It means that if you're owed $50,000 for materials on the project, the owner doesn't have to pay the general contractor that amount of money when they get a preliminary notice or in response to a lien claim, and they're not in breach of contract with the general contractor. All right, recorded liens are expressly assignable rights. Who cares? What is that about, assignments? Well, we know that assignments are when one party has certain legal rights and they execute a document and they assign those legal rights, they give them over to another party. Why does this matter? Because sometimes as a supplier, you're not going to have lien rights. You just ran out. But your subcontractor customer did send a preliminary notice and they do have lien rights. But they don't have the money to pursue it, to prepare a lien claim, and maybe they don't have the sophistication. So instead, you can be assigned those rights, step into their shoes, and now you've got lien rights for labor and materials. All right? And then you just have a separate, as part of that assignment agreement, you agree to pay the subcontractor for the labor portion of whatever you receive. The contents. Lien claim is a statement in writing verified under oath by the claimant, by an authorized representative, which is the lien service or an attorney, that contains the following. First, a legal description of the lands and improvements to be charged with a lien. It's very important that you know that lien claims in Arizona must have an accurate legal description. All right? You can't get that part wrong. It can't be a street address. It can't be cross streets. It can't be a general description of the project. It's got to be the right legal description. And at this stage of the game, unless you're very good at looking up this information, and as I say, generally through the assessor's office is where we look up that information, because it's got links that take you right into the county recorder's website. You can get the deed. Exhibit A to the deed will be the legal description. Unless you want to put yourself to that task, it's better to pay somebody else to do it. All right? The name of the owner or reputed owner of the property concerned, if known. Now, two things here, two lookups here. First of all, again, the deed is going to supply that information to you, who the owner is. And you might want to check with the Corporations Commission, if it's company that owns the property, to make sure you've got that information right. All of that information is available online. You go to the Corporations Commission, you type in a business entity search, it'll tell you the correct name. It will also give you service addresses for a corporate, a business owner of the property. All right? A statement of the terms, the time given, and the conditions of the contract if oral, or a copy of the contract if it is written. Listen, your contract with your customer may be 20 years old and you lost it. That happens all the time. The problem in that instance is that the courts are beginning to require written contracts attached to the lien claim if there was at any time a written contract. All right? It used to be that, hey, if I can't find the contract, we're just going to describe what is in the contract itself as a part of the lien claim. The terms are 30 days after the invoice date or when it's due, 10% per annum interest, yada, yada. Simple as that. Again, some of these a practice, and the appellate court has indicated that the practice is that you can either describe the contract in sufficient terms in the body of the lien claim or just append the written contract to it. But that's not what's happening in the courts. So, if you have a written credit application, it's got to be attached to the lien claim. If you can't find the credit application, here's what you need to do. Get a regular form that you typically use or that you used in that instance that has the terms, okay? And then attach the invoices to it. The two combined are going to have the sufficient terms, and then it's a verified statement that, you know, a similar credit application was signed. All right? That's going to pass muster. But this is pretty onerous, and by contrast, California doesn't require these exhibits. All right? A statement of the lienor's demand after deducting just credits and offsets. How much you owed. A statement of the date of completion of the building, structure, improvement, of any alteration or repair. If you know when it was completed, you put it down. If you're not sure, just say, believe it's not complete. But on best faith, you do that. A statement of the date you sent the preliminary 20-day notice, and a copy of the notice and the proof of mailing shall be attached. All right, what's proof of mailing? It's an affidavit of mailing as to the date that the preliminary notice went in the mail. And then it's the preliminary notice as Exhibit A to that affidavit, and the certificate of mailing or other proof of service that satisfies the statute as Exhibit B to the affidavit of service. Now, you don't have to fill out the affidavit of service the date you put the preliminary notice in the mail. It's not required. All that's required is someone with sufficient authority to look at the preliminary notice, the certificate of mailing, and it can be 6 months after it was put in the mail, and they sign an affidavit of service. That is sufficient and enforceable by the court. Okay, times for recording. A claimant has to record the lien no later than, we're going to start with the second bullet point first, 120 days after completion of the project. Not after you completed the supply of your materials to the project, but 120 days after the entire project was completed. Now, it's very important that you know the definition of the project in your instance. That 4-building office park that we're talking about, is it a consolidated contract for all 4 buildings, meaning that even though you supplied to building A on the front end, and 2 years later, 3 years later, the whole project is finished in the form of landscaping being completed on building D, that gives you a lot of leeway in there. But if there are separate construction contracts for each of those 4 buildings, then you're dealing with a much shorter time frame. How do you find out if the project is completed? Generally, we look to see if there are open construction permits in the local construction building office. And if the permits are closed, we find out the date of close of the permits. Sometimes we talk with the general contractor if we feel that information is accurate that we're getting. And in all instances, we calendar very conservatively. The most conservative way you can calendar on this is 120 days from the last date you supplied materials or labor, because you know it wasn't complete on the date you supplied materials or labor. All right, so completion by statutory definition is defined as 30 days after a certificate of occupancy issues. Now, the C of O, if one issued on the project, gives you a date certain to work from. But not all times are C of Os issued on a project. Or 60 days following continuous cessation of labor. All right? So this means that the 120 days here that you have to record a lien claim is actually 150 days after a certificate of occupancy issues, or it's 180 days after that first day when labor ceased. Because some projects just stop. They don't get complete from the purpose of occupancy, but nevertheless they're complete from the requirement perspective of you recording a lien claim. And so when you see it running for 60 days with no labor, then that 60th day is your first day for counting 120 days, or the 61st day. If no building permit is issued, or if the governmental body that issued the building permit for the improvement does not issue final inspections and written final acceptances, then completion means the last date on which any labor or materials were furnished to the property. Okay, so this is the shortest time frame you're dealing with. If a C of O was supposed to issue and didn't, or if the school board was supposed to vote on accepting the project and they just never did it, then you're at 120 days from the last day you supplied. So it is important to keep track of the last date you supplied to the project. Now that was page 6. If you go to page 7, there's an animal out there called a notice of completion. That was the first bullet point that I skipped over, where it said 60 days. Because I wanted to explain what a notice of completion is, first of all. A notice of completion is a document that is not at all elaborate. It's a very simple, benign-looking document. And if you turn to page 12 of your written materials, you'll see what one looks like. There's not a lot to it, and certainly not as much as the lien claim we're about to show you. It's a legal notice to subcontractors and suppliers by the owner that the project is completed. It has the date of project completion. It has the name of the owner, the name of the original owner, the general contractor. It tells you where the project is. It gives the legal description. Although the legal description isn't required, a project address is sufficient as long as that address is correct, and the nature of improvements. And then if you turn over to page 13, it explains that, hey, this is for purposes of shortening your period to record a lien claim by matter of law from 120 days to 60 days. And then there's a verification from the owner or an authorized representative, such as the general contractor, that I sent this out to everyone. All right, let's turn back to a description of what these notices of completions do, and that's page 7. Okay, so there's the laundry list again. An NOC must contain the following: the owner's name, the nature of the interest, the legal description, the name of the original contractor, the addresses, predecessors and interest, and the nature of improvements to the real property. You know, what do you supply? The recordation. The notices of completion have to be recorded in the office of the county recorder where the project is located. And for service, the person recording the notice of completion has 15 days after recording the notice to mail the copies containing a statement of the date of recording to the owner, the original contractor, and all persons from whom the recording party has been properly served a valid preliminary notice. Now, there's no rule as to when you have to record the notice of completion. The project just has to be complete at the time you recorded it. So it can be weeks, it can be months after the notice of completion is recorded. Obviously, it doesn't give you much benefit if you wait 60 days after the project is complete to record a notice of completion, because all you did was shorten the period of time from 120 days to 60 days, and there was only 60 days left in the 120-day lien recording period at that point anyway. All right? So it doesn't matter when they record it, but once they record it, they've got 15 days to mail the copies of the statement of the data recording to the owner, the general contractor, and all the parties who have been properly served a valid preliminary notice. In the face of late service of the notice of completion, what happens? It just is of no effect, and you are left with your original lien claim rights, which put you back in a 120-day time frame. Okay, service, well, now we're skipping back to lien claims. So that's what an NOC is. Now let me tell you something. We used to see notices of completions all the time in the middle 2000s, all right? They were wrong most of the time. At least half of the time, the date of service was not within 15 days after the recording date. And they were just facially invalid. People didn't know what they were doing. And then they got really good. And then we had to send out instructions to all the clients. The second anyone sees a notice of completion, get it to us right away, because that just chopped your time for recording a lien claim in half. And in California, all these dates are half the periods of time, so it's a very short fuse. And I represent a couple of painting companies. They're on the tail end of the project, so you can imagine, you know, the fire drill bell that goes off the second of a notice of completion comes in. Then all of a sudden, the NOCs stopped. We stopped seeing them. Well, why? Because it's ringing a dinner bell. When you send out a notice of completion, people who weren't necessarily going to record a lien claim go, well, I got to do it now. So really, it was just a cattle call, and all these lien claims would get recorded on a project. And it wasn't helping. It wasn't serving the purpose, which is to actually prevent lien claims from being recorded. So we just don't see them anymore. Service of the claim of lien. Service of a copy of the lien claim must be made on the owner of the property within a reasonable time after recording the lien claim. It's presumptively 14 days, a 2-week period. I've gotten into fights with law firms because they waited months and were very dilatory about the service. And the courts really look over their eyeglasses at parties who don't get it served within a couple of weeks. Notice it only has to be served on the owner of the property. We serve it on everyone. If you're not afraid of your customer and the owner and the GC knowing that a lien claim has been recorded, then send it to everybody. Put them on notice so that you can get paid. There are instances where subcontractor suppliers don't want the owner, don't want the general contractor to know that a lien claim has been recorded because it'll make them upset. And frankly, they're not really going to find out any other way unless you serve it. So they may say, well, I don't want my lien claim rights to run out. So I want to record this, but I also don't want anyone to know that I've done it. Can you stall? Can you stall on the service? Stay within the statute. Give me a little more time to work this out. Then we'll just record a release of the lien claim if I get paid. Absolutely. But you know, you're getting a little dicey if you're going beyond, say, a 30-day period or a 60-day period. Lien foreclosure, you've got 6 months within the last date that you recorded your lien claim to foreclose it in court. You know, what is that? Well, unfortunately, we're all a little bit more familiar with what the term foreclosure means these days. It means that it's a lawsuit filed in court. It generally goes like this. This is the way a lawsuit looks if you've never experienced one before. Okay, it's going to have a little identification of the parties on the first page and the superior court that is being filed in. It's going to have general recitations, which is these are the names of the parties, and this is the venue and jurisdiction for this particular lawsuit, being Maricopa County, Arizona. And everybody resides here, does business in that county. Then you're going to have general allegations. This is what the parties did. They engaged in a contract and they supplied some materials to this particular project. Then it'll be count 1, breach of contract. Okay? This is the claim you're making that your customer breached the contract with you to pay you for materials supplied, or that the subcontractor is making with, against the general contractor, they breached their subcontract, or the general contractor is making against the owner saying that we were not paid on this project. Okay, that's count 1. Count 2 then will be a personal guarantee. breach of personal guarantee, if any exists. But then the next count is the lien claim count. Lien claim foreclosure against the property owner. And you described, you met all the requirements of the lien claim. You attach as Exhibit A or B the lien claim itself to the lawsuit. And you ask for a declaratory judgment of foreclosing your lien claim against the property, giving you the right to sell it at auction and to pay yourself out of the proceeds of that sale. And if there's any left over, then it goes to the owner, but you get paid first. All right? That's how that works. Now, you've got 6 months from the last date your lien claim was recorded to do that. It is a nightmare to actually foreclose these liens, particularly these days when so many buildings are underwater, and then to try and sell them at auction. We represented 2 or 3 parties to the Tempe Towers foreclosure action that went into bankruptcy court, came out of bankruptcy court. I think there were about 20 or 25 different lawyers on that. And I think we all did a hand count as to who in their entire career had actually sold a property at auction under a lien claim. And I was only second or third on that kind of a sale back in the 90s, and most of the people had not even done that. It's just not done. It's a nightmare to actually try and get that declaratory judgment and exercise your rights pursuant to it. So you want to use that 6-month period to get paid, all right? And even partial get paid as opposed to foreclosing the lien claim, all right? The lis pendens must be recorded within 5 days of filing. What the heck is a lis pendens? This lawsuit is not going to get recorded in the county recorder, okay? So the world doesn't search the county lawsuit records, and they don't know that there is a lawsuit foreclosing a claim of lien on this project. But the lis pendens is Latin for claim pending, all right? And that gets recorded with the county recorder for any title company to see when they're doing a title report, and it says there's a lawsuit that's been filed on this particular property, and it's currently in litigation. Now, the lis pendens also has to get recorded within 6 months of the date of the lien claim, all right? If you do your lien claim 5 days or sooner in your 5 days before your time runs out or earlier, then you've got 5 days after your lien claim is recorded to record your lis pendens. If you wait until the last day of the 6-month period to record your lien claim, you've got to record your to file your lien claim. You've got to record your lis pendens the same day. So there's 2 different documents that your attorney is filing: the lien claim foreclosure over in the Superior Court, and then the lis pendens. They're recording that with the county recorder. If you give your attorney only 1 day to put together this lien claim lawsuit, expect that they're going to have to work very hard for you, push everything to the side, and they still may not be able to get it done. All right? So give them a little more time than that. John, keep that in mind. Sometimes I don't see clients until seminars. And yesterday, there were a bunch of clients I saw for like the first time. Margaret over here, Margaret Smith, raise your hand. Lumber Products of Oregon came down from here. John Slemkowski, good to see you. A lot of other people for the first time I see at these seminars. We all live electronically, and that's the way to do it, frankly. You want to have a relationship with your lien service company, with the general contractor or owner on a project, with your attorneys on email. Okay, I'm a big fan of email. I'm not as big a fan of telephone calls because email lets people respond wherever they are on their own time frame. It's really the way to get things done. Also, with email, there's a record. Okay, with phone calls, with text messages, not so much. Let's look at what a lien claim looks like. Up on 8, I think. This is how we do one. And, you know, this is an animal from the early 2000s and mid-2000s. We use different forms at times now because this looks like a lawsuit. It was intended to look like a lawsuit. And this is on page 8 of your materials. This is very much what the first page of a lawsuit looks like, and that's to a purpose. We wanted owners to go, oh, this would not be very hard for these folks to turn this into a pleading and file it in court. As we scan down, we see, well, we see who the lien claimant is. That's you. We see who the owner is. You got to get the date of the owner indication correct. You don't have to have their state of incorporation. It's nice to do it. It says you know what's going on. The prime contractor, the subcontractor, and the lender. All right. Notice and claim of mechanics and materialman's lien. We put that to the side. Notice the county is up at the top of it. You got to identify who the county is. Coming down, this is where you identify who is signing the lien claim. Moving through the lien claim, the name and domestic address of you, the claimant, is paragraph 3. Here's what we furnished, but let's stop and read this one. Claimant furnished labor, materials, fixtures, whatever. General description of materials, you punch that in. Obviously, this is a Word document that we use as a template. On that certain parcel of land situated in Maricopa County, sought to be charged together with improvements with the lien hereby claimed. Said property is located at. This isn't necessary, but we put it in anyway, the project name and street address, and has a legal description described in exhibits, what have you, which are attached here too. That you have to have. I do not like keystrokes. Okay, so as much as possible, because keystrokes are where mistakes happen, as much as possible, we want to copy and paste out of documents, whether for the legal description, whether for the service addresses or the names of entities. We want to be able to copy those out of the Corporation Commission website and place them in our document. And for the exhibits, if possible, we're going to print that off of the deed from the recorder's office, and we're going to attach that directly to our lien claim without keystroking it in. Now, if you're going to keystroke things in, then you got to have 2 sets of eyes looking at it. Somebody's got to be looking at the legal description online or in the print off of a deed while the other person reads it aloud. I'm a big fan of that. If you're doing this internally, you got to be staffed up and have a pattern and practice of people pairing off before it goes in the mail. Do we cheat on occasion? Yes. When it's super duper easy and it's clear as a bell, but you got to really make yourself focus and get it right. And it's not the way you should live all the time. 4, the owner, reputed owner of the project is, again, if it's out in the public domain, the owner name, and you relied on that, you're probably fine, even if it's wrong. Claimant was employed by and furnished material to the following contractor and reputed agent. This is the GC or the subcontractor who's operating as the GC. Okay, it's not your customer. Point 6 is your customer. Claimant charged and invoiced your customer for above described labor pursuant to written contract. Change order. Look, if this is for materials at the end of the project and a change order, you've got to have the change order attached as well. That's an integral part of the contract relationship. If it's an oral contract, state the terms, the time given, and the conditions of the contract. If you've got an oral contract, if your customer never filled out a credit application, if you as a subcontractor never entered into a subcontractor agreement, then state the terms of the arrangement and attach the invoices. Okay? How are we doing on time? 9:30? What do we got till? Oh, we're doing great. Does anybody know, are we 10 or 10:15? 10? Okay, so we got 30 minutes. Okay, moving on. Copies of the contract, change order, and invoices for paid and unpaid balances are attached as B1 through B whatever. The invoices don't have to be attached here. Okay? The invoices we frequently attach just in case there's a deficiency in the contractual terms and they're not complete. Here's the thing, and now we're getting a little nuanced here, but that credit application is called an open account that things can be charged on. At the time that you terminate the contractual relationship and sue for a balance due or record a lien claim, it becomes an account stated. Okay? So the credit agreement itself is really not the entire contract because it doesn't have a price term. I say all the time, 99% of the contracts formed in the world are actually oral contracts, but they all have to have a price term. Now the price can be barter, it can be labor in exchange for labor, that's still a price. Sometimes the price is money. So you want to have those, you want to have a statement of account saying how much is due or the invoices to flesh out the credit application. Now if you have a subcontract and it's got the price term in there, then you've got a solid contract right there. It's complete. But the open account agreement is not the same thing as a closed account. The closed account must have a price term, and that's satisfied through, say, invoices or statements of account. And also, they have other dangling terms and invoices that might not be in the credit application, such as due on 30 days, 10% per annum, things like that. Claimant demands, after deducting all adjusted credits and offsets, a dollar amount. This is what you're owed, plus reasonable attorney's fees and interest accruing at the highest legal rate applicable from the time of claimant's fulfillment of contract until paid. The legal rate that's applicable will be your contract interest term if it's stated. If not, then they just amended the Arizona statute, and there's some nasty 1 plus prime formula that you can use. Just have it in your contract, okay? Don't forget a rule that we went over, the 120% rule in the preliminary notice. You are limited to that dollar amount that you stated in your preliminary notice plus 20%. And also, you are limited in your dollar amount to the legitimate value of that preliminary notice. What do I mean, legitimate value? Okay. On January 1, you filed, you delivered $10,000 worth of paint to a project. On January 5, you delivered another $10,000 worth of paint to a project. On January 25, you mailed a preliminary notice for $20,000. How much is that preliminary notice really worth? $10,000. You didn't capture the first $10,000 with the preliminary notice. You only got the second $10,000 because you didn't serve it until the 25th. All right? Now, let's say that you got paid on that first $10,000. You didn't get paid on the second $10,000 worth of paint, and then March 1, which is a long time after the preliminary notice date of January 25, you supplied another $10,000. How much can you lien for? You can lien for $20,000. I'm going to come over here because I get to know this side of the room a little bit. Also want to test our media people. Can they really pivot that camera? I was stuck here for a little while, by the way, when you left the room because I couldn't go out of camera range. So I just want you to know that. So you can do your preliminary notice early. All right, you can do it early and anticipate how much you're going to supply, and you clearly captured at that point. You got it within the 20 days because you did it before the materials even hit the site. All right. 9 is, to your knowledge, the building, has not been completed. Preliminary notice was served on such and such a date. And we've indicated that you've got to supply the affidavit of mailing, the proof of mailing, and a copy of the 20-day notice as an exhibit. In Arizona, you got to have a lot of exhibits to your lien claim. I promise that we recorded this. That's what you're saying in paragraph 11. Because, it's not the recorder who's reading paragraph 11. It's the owner, the general contractor, whoever, who's reading it. And they want to know that you actually have already sent this to be recorded. And then, whereby pay us. And there's the authorized representative of the lien claimant. This can be you. You can prepare these yourself if you want, but you just got to make sure you got it right. Let's go to the timeline. All right, the timeline is found on page 14. What we did on this timeline is give you a 1-year snapshot of a project. And because paint is at the tail end of a project, that's what we're going to use as our hypothetical here. Okay? So this project's been going on for a while. This January 1's to the left, December 31's to the right, but the project is off the screen. Okay? Most of the work is off the screen. This is a 2 or 3 year project. But you supplied materials on January 1. All right? The next action item date is going to be January 21. That's the last date you can serve your 20-day preliminary notice under Arizona statutes. Now, the last date your materials and labor were furnished because you supplied a little more paint on February 1 is the February 1st date. The next thing you got to think about is when was the project completed? Project completion is a term of art. It's defined by statute in 3 different ways, as we discussed. 30 days after final inspection and written acceptance by a governmental body, certificate of occupancy, that's what that is. Cessation of labor for 60 days, the project may not be complete, but people have stopped working on it. And if no C of O issues, completion is the last date of supply of materials or labor. That's why that February 1 date matters. It doesn't always matter, but in this instance it could, because that's the last requirement or definition of completion. Now, hypothetically, a notice of completion is recorded March 1. As you can see, it can be recorded any time after completion. If March 1 a notice of completion was recorded, then you have 60 days after that NOC is recorded to record your lien claim. If there was no notice of completion was recorded, then the last day to record your lien claim is 120 days after completion, in this hypothetical, June 29th. All right? Now, the deadline to file suit is 6 months after the date the lien is recorded. All right? So if an NOC was recorded, then you've got 6 months from your April 30th date that you recorded your lien claim, and your last suit date, the last day you can file suit at that point is going to be October 30th. Okay? So with the notice of completion in this hypothetical, March 1, they recorded the notice of completion. They got it served to you within 15 days of the recordation date. April 30th then became the last date you could record your lien claim. If April 30th you recorded your lien claim, then October 30th is the last date you can sue. If no notice of completion was recorded, then you had until June 29th to record your lien claim, because under this hypothetical, March 1st was the actual date of completion. In that instance, you've got 60 days from June 29th to sue on your lien claim, and that is December 29th. And if I said record before on the suit date, it's the suit date. 6 months to October 30th. From April 30th, if an NOC is recorded, 6 months from June 29th, if no NOC is recorded, and that's December 29th as your last date to sue. Yes, ma'am? Well, you should check your own records, honestly, because if they haven't served it on you, it doesn't matter. Now, you can look it up in the county recorder's website by looking up the owner name, because the owner is the entity who's actually going to record that. Even the general contractor may prepare it for the recorder, but you can search in the grantor-grantee index and just type in the name as you know it of the owner, and that notice of completion should come up. Then it's not good against you. If you never got one, you're fine, and you can proceed with your lien claim rights. But you want to make sure that it didn't get mailed to you, because sometimes we find the trickle-up effect takes a little while. It went to somebody in the credit department. It took a while to work its way up to somebody who transfers it over to the lien service company or to the law firm. And you know, out here you've got 60 days, so really 45 if they served it 15 days after. California, it's much tighter because you're working with 90 days and 45-day deadlines. Okay. I want to talk about stop notices for a minute. And that's on page 15. And it wasn't really within the scope of what we were going to cover, but I'd like you to know the value of a stop notice and that you should use it as a redundant payment collection device. What is a stop notice? It's a device to freeze, essentially a temporary restraining order against the flow of money from an owner to the contractor, or from a construction lender to an owner, until the stop notice claimant has been paid. The owner or construction lender must withhold an amount that is sufficient to cover the stop notice claim. Okay, let's look at that again. It's a device to freeze the flow of money from an owner to the contractor, or from the construction lender to the owner, until the stop notice claimant has been paid. All right, so there's two places there that it's potentially freezing the flow of money, from the lender to the owner, from the owner to the general contractor. Where are they available? Stop notices remedies are available only on a private project. They're not available against public project or dwellings of owner occupants. The rights where you can use a stop notice are the same places where you can record a lien claim. Who can use them? Any person entitled to record a claim of lien under Article 6 of this chapter, other than the original contractor, may issue a stop notice against the owner. Issue a stop notice. What are you talking about? Well, you're going to mail the stop notice. You're going to serve it with proof of service on the owner, and then they've got to hold that money with the equivalent value of the stop notice. The general contractor cannot serve a stop notice against the owner, but a general contractor can issue a stop notice against the construction lender. You're skipping up one step. You're skipping the intermediary party. So the GC's got to skip the owner. You are skipping the GC as a supplier or subcontractor and serving it against the construction general contractor. Are they effective against lenders? Stop notices are not effective against construction lenders unless they are bonded. You got to have a bond attached to it. Now, a lot of companies don't want to go out and pay the premium, get a bond to serve it with the stop notice. So they don't even try to serve this against the lender. You can serve a stop notice against the lender without a bond, and they might abide by it. They probably won't. They'll recognize that there's no bond. Lenders can ignore those non-bonded stop notices. The stop notice against the owner does not have to be bonded. Okay? What if there are defects in form? Unlike lien claims, it's not invalid by reason of a defect in form if it's sufficient to substantially inform the owner of the information required by the article. What is going on here? What is this about? Well, the legislature got an earful when all these lien claims are being filed against projects, and they wanted to provide an alternative remedy where there's not a contamination of title and people are still getting paid. That's what a stop notice is. This is not recorded. This is mailed like a preliminary notice. What information has to be in there? It's signed by the claimant. All right? It's a description of what you supplied. It's the name of the person to whom these materials were furnished. It's the name of the entity. It's the amount and value of those materials already furnished and the total amount agreed to be furnished. So there's a little bit of arithmetic coming up here in the next bullet point. The amount of any payment received by the claimant for the labor, materials furnished, and what's left to be paid. It's the same thing. What am I owed? And the name and address of you, the claimant. All right? Now, what if someone demands that I serve a stop notice? There is a right for the owner and general contractor to say, I want a stop notice if anybody's going to serve it within 30 days. This never occurs. Okay? It's again ringing the dinner bell. All right? Let's look at what a stop notice looks like. And you're going, didn't I just look at this? No. That was a notice of completion, all right, that the owner is recording, or the GC is recording on the owner's behalf. This looks very similar, but this is a stop notice that the supplier, the subcontractor, or even the general contractor against the lender is sending out. This is page 16 in your materials. Legal notice to owner to withhold construction funds. If it's a legal notice to the lender, then you're just going to type that in instead. It's got all the same information there. The project or improvement, it's got an address, and that's sufficient. And notice is hereby given that me, the claimant, furnished labor, materials for improvements at the project known as blah blah, located at blah blah, and this is what I gave you. I gave you paint. All right? And then here's your little bit of arithmetic. This is how much we supplied to the project. This is how much we've been paid. This is how much we're owed. So hold that money. That's what this is. It functions as a TRO. Now, you sue on this just like you would sue to foreclose a lien claim. So sometimes if you recorded a lien claim and you've sent out a stop notice, your lawsuit now is going to be count 1, breach of contract, count 2, personal guarantee breach if you've got those, count 3, lien claim foreclosure, and count 4, stop notice foreclosure. When do you have to serve these? Let's go to the timeline. This timeline works almost exactly the way a lien claim timeline works. On this hypothetical, again, January 1 you supplied the paint. January 21 your last day to serve a preliminary notice. February 1 is the last day you supplied paint. The completion in this hypothetical is March 1, defined as 30 days after the certificate of occupancy issued, cessation of labor for 60 days, or no C of O issue. Completion is the last date of supply of materials or labor. Note that the third point is the shortest of these three. All right? That is 120 days to record a lien claim. The top one is 150. The second one is 180. NOC recorded, if at all, on March 1. Hypothetically, you must serve the stop notice before the expiration of the time allowed to record the lien. I'm going to read that again. You must serve the stop notice before the expiration of the time allowed to record the lien. So if there was a notice of completion recorded, the last date to serve a stop notice is 60 days after the NOC was recorded. In this hypothetical, our timeline is running exactly like what you just saw in the lien claim timeline. If there was no notice of completion recorded, the last day to serve the stop notice is 120 days after completion. Again, if there was no NOC recorded, the last day to serve the stop notice is 120 days after completion. When do you sue? You can file suit anytime after 10 days from the date of service, but before 3 months after expiration of time allowed to record the lien. 3 months, not 6. A lien claim, you have 6 months to sue and foreclose it from the date the lien is recorded. A stop notice, you have 3 months to sue on this after the stop notice is served. Okay? So, hypothetically, if the stop notice is served April 30th, then the last day to sue on the notice is July 30th. 3 months, not 90 days. On the lien claim side, 6 months, not 180 days. All right? Now, if there's no stop notice served, then June 29th was your last day to record a lien claim, and therefore your last day to serve the stop notice. 3 months after that is your last day to sue on that stop notice, and that's September 29th. So, the only thing that's changing here in this hypothetical are the legs on the stop sign. Those legs shift to the left because you're dealing with a 3-month period. In the lien claim timeline, those legs shifted to the right because you're dealing with a stop notice, with a lien claim 6-month period. All right? That's the only difference. If you went back and forth between your sheets here on your timelines, the only thing you would see different is that those legs shift to the right because it's 6 months for a lien claim, it's 3 months for a stop notice. How are we on time? Okay. We're going to close this out with 2 general categories of thoughts. First, I want to talk about attorney's fees. Attorney's fees are... And by the way, as we leave stop notices, there's no reason you can't do both stop notices and lien claims. In fact, I highly recommend that you do both. Why? Because it's more sabers to rattle in a scabbard. I finally found out what a sword goes into. It goes into a thing called a scabbard. All right? So you rattle the stop notice and you rattle the lien claim warnings at the same time, and you say to the project owner, the general contractor, we can sue on these stop notice rights, and we're going to unless we're paid. Well, 3 months comes and the project owner says, I just don't have the money yet from the lender on this. You can let your stop notice rights expire because you still have your lien claim rights in your back pocket. But if they have the money and you're going, oh, I get it, you're just not going to pay, then what you're going to do is double down, and you're going to file suit to foreclose both your stop notice rights, and since you're already suing and you're in court on your stop notice rights, you'll probably bring those lien claim rights forward with you and foreclose those at the same time. You're going to hit them with both barrels. All right? The stop notice gives you an additional strategic right of collection. It's a very simple document to send out. There's simply no reason not to send it out at the same time. Okay? Your rights to recover attorney's fees. Folks, it's pay to play. Okay? It's an expensive proposition to go into court, and you need to be able to finance that litigation. There are very few attorneys in town who are going to fund that litigation for you just out of the possibility that they're going to get a full award or most of their attorney's fees awarded against, in their favor under statute by the judge, awarded against the subcontractor, the property owner, whoever. Because every one of those counts that I described, the breach of contract, the personal guarantee, the stop notice, and the lien claim, all permit reasonable awards of attorney's fees by the court. But guess what? The reason you're not being paid is generally because somebody doesn't have the money to pay you. And they're not likely to have the money to pay all of your attorney's fees in addition to their attorney's fees, in addition to the amounts that you want to recover. So these numbers have to make sense for you to file this kind of a lawsuit. In general, I'm thinking a number that's in the above $25,000 range, $35,000 or more, $50,000, you know, for sure. And once you get above $50,000, you're even in that range of prices where you can afford to take an appeal if you lose, if you think you're going to win on appeal. Okay? So if an attorney says, don't worry about the attorney's fees, the other side's going to have to pay them, my goodness, you know. First of all, that attorney is not going to wait on these 30-day invoice cycles for you to pay, all right? Second of all, no court awards 100% of attorney's fees unless there was bad conduct on the other side. They're going to come up with a number that's somewhere between 50 and 75% of those attorney's fees. And depending upon the amount of attorney's fees, that loss of the 25 or 50% of the award can cancel out the net recovery that you're going to get out of the project itself. So you really got to think through the attorney's fees factors. And that's the reason you got to be on top of your aging reports so that you can use that full period of the 90 days, the 3-month period after you serve your stop notice to negotiate, the 6-month period after you record your lien claim to negotiate, so you stay out of court. All right? So there's a page that tells you what kinds of fees are recoverable. You just don't want to go there if you can avoid that. Let's go to page 20. We're going to end here. These are the waivers and releases that you're going to be confronted with. There are 4 kinds under Arizona statute. There is a conditional release on progress payment. That's part of the money you owed on the project, not all the money you owed on the project. There's an unconditional release on progress payment. That's saying my rights are gone through a particular date certain. And you got to make sure you've been paid everything you're owed through that date that shows up on these documents. Then there is a conditional waiver and release on final payment, meaning everything you were going to get paid, including that retention amount, that 5 or 10% retention, that's got to be in there. Or don't sign a conditional waiver and release. And then finally, an unconditional waiver and release on final payment. Again, that is the last money you're going to see on that project from the owner or the general contractor if you're a supplier, if you're not in direct contract with those parties issuing the money. Now, the legislature issued these releases. You do not have to sign a release that is exactly the same as what appears by statute. And a lot of GCs and owners don't realize that. It just means that it's not going to get the automatic stamp from the judge saying, okay, this complies with the statute, and because you exactly copied it. You can do your own release. It just has to stand on its own as a contract of waiver and release. People ask me all the time, all right, you supplied paint through all kinds of different months of January, all right, and it comes out to $50,000. They want to issue you a payment for $30,000, and they're going to pay you, let's go to the unconditional progress, and we'll read this aloud. It's an unconditional waiver and release of lien, bond, or stop notice rights on progress payment. The undersigned's been paid and received a progress payment in the sum of blank dollars for all labor, services, equipment, or material furnished to the job site or to blank, which is the customer, your customer, the person with whom you contracted on the job of, my Safeway at 32nd Street in Camelback, all right? And does hereby release any mechanics lien, any state or federal statutory bond right, any private bond right, any claim for payment, any rights under any similar ordinance, rule, or statute related to claim or payment rights for persons in the undersigned position that the undersigned has in the above referenced project to the following extent. Okay? Here's the money language. The release covers a progress payment for all labor, services, equipment, or materials furnished to the job site or to your customer through blank date only, and does not cover any retention, pending modifications, or changes or items furnished after that date. You supplied $50,000 worth of paint in January. All right, they are asking you to waive your rights to record a lien claim or make a bond claim through January 31st, but they're only going to pay you $30,000. Don't do it, because even though you weren't paid all $50,000, by saying you've been paid through January 31, you waive those $20,000 worth of lien and payment bond rights. Okay? Now, people ask me all the time, look, I don't go by dates, I go by invoice numbers. All right? We supplied paint in $5,000 increments 10 different times during the month of January. Here are the invoice numbers. They want to pay 30,000 of those invoices. Can I just write down at the bottom the invoice numbers that they're paying and say the rights to the rest of them are reserved and just scratch out the through date? Yes. and that is completely enforceable. But you may be in a position where you or your advocate, say your attorney, is going to have to explain that to the general contractor or the owner, that you can vary from this form. Reasonable people get to enter into contracts, and nothing about this form changes any of that. It's just that you would have to stand in front of the judge, maybe if you had a lawsuit, and just explain that. Good judges, particularly those familiar with it, get it in about a millisecond. All right? Judges who don't know this area or are not good judges don't get it. Okay? So one of the things you got to do, and we do it quite frequently, is exercise your one peremptory strike on a judge. If you see a judge who you know just doesn't get it, they came off the criminal bench, they're not familiar with this stuff, you strike them, you get them out of there, and you take your chance with the next judge. But you've got to educate sometimes the GC or the owner. The GC sometimes may have to educate the owner and explain to them that you have a right to deviate from this form if the form doesn't work for you. And the world pays invoice numbers. The world doesn't pay by dates. It just doesn't work that way. So yes, you can modify this. Now, notice this block down at the bottom. The document waives rights unconditionally and states that you have been paid for giving up those rights. This document is enforceable against you if you sign it, even if you have not been paid. If you have not been paid, use a conditional release form. Okay, folks, you're a supplier. Your subcontractor comes to you, says, I've been paid by a joint check, which is a two-party check, okay, for $20,000. You're owed $10,000 in paint. I, the subcontractor, am owed $10,000 in labor. I'm going to take this $20,000 check. You sign off on it. I'm going to deposit it with my bank, and here's a $10,000 check from my own account for your materials. Sign this unconditional release. It's all good. Or sign a conditional release for your $10,000. I'll give that to the general contractor, but again, here will be my check, and I'll keep the builder's check. Don't do it. Don't do it, because if their check bounces, all right, if their check bounces, that unconditional release means your lien rights through that progress date for those invoices are waived. All right? If you have any doubts about the check you're going to get from your customer, then you got to keep the builder's check. You got to keep the owner's check and say, let's do a little bit differently. I'm going to cut you a check for your labor portion, and I'm going to keep the joint check endorsed here. That's how you want to do it. Now, I advise, it kind of depends on the situation. Frequently, I'm advising clients, if they're suppliers, to cut the check for the labor to the subcontractor. They keep the builder check. We'll take bank drafts from general contractors. I mean, I haven't had a general contractor check bounce. So, and there's a trouble damages statute in Arizona that you send a certified letter. If a $10,000 check bounces, you can sue for $30,000 if they don't replace it within the statutory time frame. Let's go to unconditional release on final payment. This is the big dog here. It looks just like the conditional release, but now this is the last money you're going to get on this project from the owner before you waive your rights to lien. Something you want to be aware of, the legislature didn't do too good a job drafting these, I have to tell you, because the release here says, and look about 4 lines down, you're going to release any mechanics or materialman's lien, any state or federal statutory bond right, any private bond right, any claim for payment, and any rights under any similar ordinance, rule, or statute. All right? What does that mean? All right, your subcontractor wasn't completely candid with you. And it turns out that the $50,000 worth of paint was just a little much to paint the additional garage that was attached to the Phoenix Children's Hospital. It turns out that $20,000 of that paint went to an entirely different project. And the owner says, okay, we got $30,000 worth of paint, we're going to pay for that. We're not paying you the other $20,000, and we want an unconditional final from you. So what you've got to be careful of is you retain your rights to deal with your subcontractor, potentially file suit for the other $20,000. But this language, as written, says you're going to waive any claim for payment under any similar rights related to the job of whatever. And your statement of account just identifies Phoenix Children's Hospital. All right? So what you've got to do is scratch out any claim for payment, or put a caret above it, any bond or lien claim for payment, and a caret lien or bond rights under any similar statute. All right? We have these in Word, so we make that change automatically. And we don't even explain it to the GC, the owner, because they don't notice it, and we have a right, we have a fairness right to make that alteration. What time are we at? Oh, okay. So the bottom line is, feel free to modify if you need to, and if you look at the bottom language there, again, this is the death penalty. Huh? Is this unconditional? This is conditional. This is conditional. All right. On the unconditional waiver and release, can you pull up real quick? On the unconditional waiver and release, it's got that block language. All right. Same thing. Don't sign this unless you've been paid in full.